So in this video, I have an update for you on 4 Second Amendment cases that are now moving forward in the Supreme Court. Also, there are significant updates in multiple California firearms cases, including the ammo ban case and the ban on so-called assault weapons in the state of California. So let's talk about this. But real quick before we jump into this video, if you think we need to strike down all these Second Amendment violations, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, we have a ton of movement on major Second Amendment cases that have been stalled out and waiting for a Supreme Court ruling in the New York State Rifle and Pistol Association v. Bruen case. Last week, we received that decision from the Supreme Court, and now all of these Second Amendment cases are now moving forward. So first, I want to talk about the cases that are currently pending before the Supreme Court and what's happening with those. And then we're going to talk about the California-specific cases that are currently on hold in the Ninth Circuit. So today we received news that the Supreme Court has distributed the 4 Second Amendment cases for conference that were on hold at that level. Those 4 cases include the Duncan v. Bonta California magazine ban case, the Bianchi v. Frosch Maryland assault weapons ban case, the NYSRPA New Jersey magazine ban case, and the Young v. Hawaii open carry case. These 4 cases have been on hold at the Supreme Court level for a really long time. These 4 cases have essentially been waiting for the Supreme Court to rule in the Bruen case. Well, now the Supreme Court has ruled on that case and has established the analysis as text as informed by history. These 4 cases are now proceeding forward. Duncan, Young, Bianchi, and the NYSRPA case have been distributed for a cleanup conference today. So today they were scheduled for conference and they went to conference today. And this is the Supreme Court doing a cleanup conference that they tend to do at the end of each term. So by the time I put up this video, the Supreme Court would have already held conference on these 4 important Second Amendment cases. Now you may be asking, what does that mean? Well, at the end of the Supreme Court term, they will typically hold a cleanup conference and deal with all the cases that have been on hold to this point. The Supreme Court will now decide what they want to do with these cases. There are a few options that they can decide to do and kind of determine what happens from here. First, they could grant and review on these cases. That would probably be the best case scenario where they actually grant certain cases, and that would be good because we would get a final determination from the Supreme Court on all of these issues, including the ban on so-called assault weapons, magazine bans, open carry, and all these other really important Second Amendment questions. The court could also simply deny review in these cases, and I don't see that happening going forward, especially because of this recent ruling in Bruen. The most likely thing that's going to happen is that the Supreme Court will grant, vacate, and remand, which is also known as a GVR order. A GVR order is a type of order issued by the Supreme Court in which the court grants a petition for certiorari, vacates the decision of the court below, and then remands the case back down for further proceedings. An order of this sort is typically appropriate when there has been a change in legal circumstances subsequent to a lower court's decision. And that is exactly what has happened now here with the Bruen decision. The whole framework of Second Amendment cases has been changed because of that Bruen ruling. These cases that have been on hold are directly impacted significantly by the Bruen decision, especially because the Supreme Court rejected the 2-step approach, which all of these lower courts in these cases have relied upon to this point. With the 2-step approach no longer being valid and instead text as informed by history being the standard, the Supreme Court will likely grant, vacate, and remand the cases back down to the lower courts. In the orders, they will tell the lower courts that they must rehear the cases in light of that Bruen decision. There is also a potential for summary reversal by the Supreme Court. A summary reversal is when the Supreme Court grants certiorari in a case and overturns the opinion below without written briefs or oral arguments on the merits. Usually, summary reversal is a harsh mechanism that the Supreme Court has at their disposal. Usually, it's reserved for cases where the law is settled and stable, the facts are not in dispute, and the decision below is clearly in an error. So it's a clear error by the lower courts. It sends a clear message to the lower courts, particularly those that have been in open resistance to the Supreme Court's rulings. Essentially, it's something that they could do to the Ninth Circuit and some of these other lower courts who have absolutely refused to adhere to what the Supreme Court has said. This is unlikely as an option in my opinion, but possible, especially since lower courts like the Ninth Circuit have shown that they are willing to openly defy the Supreme Court's rulings to this point. Now, you may be asking yourself at this point, when will we know what the Supreme Court has decided to do in these cases? The answer to that is likely by the end of this week. The Supreme Court already knows what they plan to do with these cases when they put them on hold and issue their opinion in Bruen. So we will know soon how these 4 important cases will proceed forward. But beyond the cases pending before the Supreme Court, There are also cases currently in the Ninth Circuit which have been impacted by the Supreme Court's ruling in Bruen, and these are really important cases for states like California. The first case is Rupp v. Bonta, which was a challenge to California's ban on so-called assault weapons. The state of California has created a scheme that bans both a list of specific makes and models of firearms and also bans firearms with specific characteristics. California Penal Code Section 30510 bans these specific makes and models of firearms that are banned, and it's the Roberti Roos list. They have things like the Colt AR-15, Steyr AUGs, Uzis, etc. And then you have California Penal Code 30515, which is the ban on characteristics, where if you have a firearm with a semi-automatic centerfire rifle, detachable magazine, you can't have specific features on it, because if you had specific features on it, then it would qualify as a so-called assault weapon in the state of California. This case, Rupp, came out of the Central District of California, and the judge in that case upheld the decision using the two-step balancing of interest test that was just rejected by the Supreme Court. That decision was then appealed and made its way up to the Ninth Circuit before a 3-judge panel in the Ninth Circuit. Well, we just got an order from that Ninth Circuit court vacating the district court's decision and remanding it back down for a new hearing before the district court. Now, some may think that that's a good thing, that that's a win, but in reality, it's just the Ninth Circuit punting this case back down to the district court and not actually taking up the issue themselves. I actually agree with Judge Bumate and his dissent on the order. He stated, "For over a decade, our court has improperly interest balanced our way around the Second Amendment. The Supreme Court has had enough of it. With a clear language standard now in hand, we should have ordered supplemental briefing to further this case along. Instead, we instinctively kick the can back to the district court, and we do so without the benefit of the parties' position on whether our 3-judge panel could have directly resolved this case based on Bruen. A remand here may just prolong the inevitable, as we will eventually have to decide this case, adding unnecessary delays and expenses for the parties. At the very least, we should have given the parties a chance to let us know where they stand on the question of remand." So this case, Rupp, is heading back down to the lower court, to the district court, and it's just simply prolonging the determination on a case like this. The Ninth Circuit should have taken it up, but they are just simply kicking the can down the road. However, there still is a glimmer of hope, which is the Miller v. Bonta case. Miller is another challenge to California's ban on so-called assault weapons, and that one comes out of the Southern District of California, and that was ruled on by St. Benitez, where he found that California's ban on so-called assault weapons was unconstitutional. In his ruling, he in fact used the text as informed by history standard as a basis to reach his determination. After he struck down the California assault weapons ban case, after he struck down that ban, the state of California appealed up to the Ninth Circuit. This case, Miller has been sitting in the Ninth Circuit, waiting for the Ninth Circuit to rule in Rupp. Well, now that Rupp is out of the way, it's been remanded back down, Miller becomes first in line in the Ninth Circuit and can proceed forward. So although Rupp was remanded back down, Miller is now in line, and Miller has a better pedigree by the lower court, especially since Judge Benitez used the correct type of analysis. But the Ninth Circuit cases do not end with Miller and Rupp. Also, supplemental briefing has been requested in the Ninth Circuit 3-judge panel case, Rohde v. Bonta, which is a challenge to California's ammunition background checks. Rohde was another case ruled on by Judge Benitez in the Southern District of California, where he used the correct type of analysis. So Rohde now is out of its holding pattern, and they requested supplemental briefing in that case. Also, a quick note, Judge Bumate is on the panel for Rohde, and it's interesting because the panel in Rohde actually did the correct thing, which Judge Bumate said that the Rupp panel should have done in that issue. So that should give you a good idea of what's going on with all these major Second Amendment cases. Also, I wanted to just note, bear with me right now. There's a ton of issues and news that are going on right now. I'm aware of everything that's going on in California with the legislation in California, the doxing of CCW holders in California, and other things that are going on in New York and just nationwide. I'm aware of all of it. There's just a ton going on. I'm trying to get through as many videos as I can, so just bear with me. I'm aware of all that stuff. I'm going to get to videos. So if you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you guys like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.